Here we are at the start of the formal charges. Watch closely. This is where courtroom tension spikes. Notice how calm the defendant seems, but the weight of probation history and child abuse allegations is hanging heavy. Audience, ask yourself, how much does prior probation influence the judge's approach?
Yes, sir. It was out county, believe.
Huh. You can't. So this whole the defendant, are you Britney Thomas?
Yes, sir.
You're charged here with injury to a child. You've been on probation in this court since 2020.
Yes, sir.
I generally read all these, but
Pause for a second. Did you catch that? The video evidence isn't just testimony. It's digital proof circulating on social media. This changes everything in a legal context. Video evidence can be more persuasive than witness statements, and it escalates public scrutiny.
so the child abuse in this case was recorded on a video and was found circulating on social media.
Yes, sir.
Who videoed it?
Somebody that was in the car with us.
Huh?
Somebody that was in the car. I moved out here with my friend and somebody that was in the car with us when I got up to the schoolhouse recorded.
I feel sorry for the child.
It's okay.
Let's zoom in on this. The child is just 9 or 12, depending on sources. The prosecutor clarifies age because it drastically affects sentencing and statutory definitions of abuse. Notice the judge's strategy, asking for precision to avoid ambiguity in court records.
I was coming up here on your
Thomas is a single mother of 5. The oldest is 20, and she says none of the fathers are around to help. Her 4 youngest, 3 little girls and the 7-year-old boy, are now in CPS custody. That state agency says no parent can spank their child.
So
I'm gonna fight for my kids. I was
you
wrong.
were observed hitting the child with a black belt several times. Also, you were observed screaming profanities at the child, calling him the N-word and threatening to break his face in. Continuing to yell profane language at Williams, at the child. How old is the child?
He's 12 at this moment.
I'm not, I'm going to ask somebody else. I don't want to talk to you right now. We're going to talk to you in a minute. You're the defendant in this case. How old was the child and the prosecutor?
I'm not entirely sure, Your Honor. I didn't have this case at the time.
Emotional abuse versus physical abuse. This is a key legal and psychological distinction. A lot of viewers might wonder, can emotional abuse be as damaging as physical? The court treats both seriously, and here, the defendant's minimization could hurt her credibility.
I believe he was about 9.
9 years of age. Striking him and yelling profanities, the N-word, threatening to break his face. Weren't you the parent, the role model? That was terrible.
Yes, sir. No.
No, you can speak. Go ahead, but your actions speak a lot louder than your words.
Yes, sir. I never said about breaking his face.
So somebody lied about this for no particular reason?
But I did spank him.
It's on video.
I did, and you know this is the video. I did spank him. I took full responsibility for it. 2019. I went by it the wrong way, yes, sir. But he had no bruises. He was not physically abused, but mentally abused. But I took full control over it. I was very.
I'm sorry. What did you just say about the abuse?
He wasn't physically abused. He was emotionally abused.
You see anything wrong with emotional abuse for a child?
Yes, sir. Yes,
You don't think a child carries that around forever?
I've
maybe?
done it. I did. So yes, sir. I took full responsibility for it.
Well, it's what the, so while on, after you've accepted full responsibility,
Yes, sir.
there's a motion to
Buckle up. The judge is laying down the law with zero tolerance. Notice the use of rhetorical questioning and direct statements to the defendant. It's not just procedure. It's a psychological tactic to assert authority and clarify stakes.
probation here that has 10 violations. Not 1 or 2 or 3, but 10 violations, miss. I'm taking responsibility. Let me read this. Oh, are you kidding me? Committed the offense of driving while intoxicated with a child under 15 after mistreating children. You're driving around with a child?
It was 2 children, Your Honor.
2 children.
To be clear.
I'm not taking the deal. No. You don't mistreat children, and then you're about to interrupt me. You're getting a fair opportunity to be heard. But you know what? It's my choices now. It's my choices. I don't have to take a deal. It's up to me. And we're going to have a hearing, and we're going to hear the good and the bad and the ugly about this, all about you. And then I'll get to make a decision, okay? But I'm not going to take 3 years. No, that sounds terrible. That's minimal. You can grimace all day long, but it's minimal for harming a child. Do you understand? That's not tolerated in this room. Do you understand? Mistreating a child. Do you understand? Yes or no? You don't understand. From your life, from your silence, you don't
I
understand.
completely understand, but I have no say so. I thought this was my hearing.
Oh, you got a hearing, but it's up to me to decide. You see,
Here's a classic courtroom maneuver, negotiating scheduling while maintaining pressure. The defendant hopes for delay. The judge balances fairness with accountability. This is where procedural strategy meets real-world logistics, something often overlooked in viral courtroom clips.
I think what you do is you've gotten into a position with your children, I guess, in your environment where you are in absolute control, which means you can harm children at whim and be and you can interrupt the judge at any time. Here's what's going to happen. Here's what's going to happen. I don't take the deal. We're going to have a hearing. When can y'all be ready for a hearing?
Right now.
Our officers are from Houston, so we would ask for just a little bit of time whenever the court is available.
Friday.
I don't think I can get them here by Friday. One of my officers is the captain of the fire department, and he's working 72 hours straight this week.
When can you be ready?
I need at least 3 weeks notice from my firefighter so that he can make arrangements.
To do what?
Give them testify.
All right.
What I'm allowed
You
to
got it.
He did notify us that they were shorthanded over there right now in the fire department.
You have a reasonable amount of time to get them.
Okay.
And Judge, I did tell the prosecutor that this was going to be a plea so that she could cancel them in enough time.
Okay.
So it's not,
It's-
she would have them
it's-
here, I'm sure.
Yeah, this is information I never know about until we get up here. And I'm not accepting a plea. We're going to have a hearing on it. I'll give you 3 weeks.
Okay.
3 separate 3 weeks. That is all.
All right, we'll talk about it.
All right, what's next?
Well, we have
Seldom do you
Mr.
hear too many people minimize harming a child, but the mother, I think.
At least as far as I'm concerned, Judge, we have Mr. Stokes who wants a hearing, and I believe the prosecution is